the Illinois State Police have had enough with these obstructionists, and they've been intervening against the governor's orders. Dragging that guy away. Looks a little different than the Portland Police Department, doesn't it? Good for them. So this week, the unelected black robe tyrannical inferior district trial courts have issued yet another sure to be reversed, idiotically reasoned, obstructionist temporary restraining order against our great and powerful elected Article 2 executive branch President Donald J. Trump in the exercise of his core and plenary powers as Commander-in-Chief of U.S. military forces. This time, the feckless and obstructionist order was issued by federal judge April Perry, class of Biden 2024, raised to the federal bench on November 22nd of last year, after Trump's election as president, and on a 51-44 Senate vote. And as is common to these Biden federal bench nominees, Perry has zero prior judicial experience, and her background consists mostly of working for various left-wing activist organizations. And in this TRO against Trump, Perry is obliged to simultaneously apply a tortured reading of the relevant statute, Section 12406, that authorizes Trump's activation and deployment of the National Guard, as well as apply her own judgment as an Article 3 inferior district trial court judge to override the judgment of the elected Article 2 executive branch commander-in-chief on whether the circumstances on the ground in Chicago warrant calling out the National Guard. This is a combination resulting in a grotesque overreach far beyond the legitimate Article 3 authority of a federal court judge, as well as being an obvious violation of the Constitution's separation of powers and an infringement of the core and plenary commander-in-chief powers of the Article 2 executive branch president, elected by the whole of the American people to carry out our political will. And the trick is this. A statute will say a president can do something, fire somebody, stop spending of money, activate the National Guard, if certain conditions are met. And the Supreme Court and the Court of Appeals will always say, well, whether or not the conditions are met, that's really a call to be made by the president. That's his job. He's the Article 2 executive branch president. He makes those calls on whether the conditions have been met. And when the federal judges, the unelected black robe tyrannical inferior district trial court judges, realize they can't contest the president on these findings of fact, on any reasonable reading of the statute, they come up with a reading of the statute that makes it impossible or insane to conclude that the facts have been realized. So they can't second guess the president's perception of what's happening, but they'll change the definition of what the condition is that has to be met so that it can't be met by the facts on the ground. They have to give deference to the president, but they'll say, well, we'll give deference to what he thinks is happening on the ground, but we'll change what the statute requires in such a way that it can never be satisfied, or certainly not satisfied by what Trump wants to do. The effect is they get to issue a temporary restraining order. They obstruct the president in his commander-in-chief functions for 2 weeks. In 2 weeks, they invariably extend it for another 2 weeks. After the month, they invariably extend it for as a preliminary injunction for the duration of the litigation, which could be months or years. Of course, by then, the appellate courts or the Supreme Court is hearing the matter, and these unelected, black robe, tyrannical, inferior district trial court judges get reversed. They get reversed, and they know they're going to be reversed. It's all a matter of simple obstruction of the president, which is why they should be impeached. They're not acting as federal judges in good faith. They're acting as political activists to obstruct the president, just like Chuck Schumer talked about after the president won. He said, don't worry about it, folks. The Democrats' leader in the Senate, don't worry about it, folks. We've gotten more than 200 federal judges approved to the federal bench under Biden. They will stop this president. Explicit political obstruction. We're going to need a rule pretty quick out of Congress whether it's written and formal or whether it's informal, that when one of these feckless, unelected, black-robed, tyrannical, inferior district trial court judges appointed by Biden, when they get reversed on appeal, in part or in whole, by either their Court of Appeals or the Supreme Court twice in a year, they're gone. It's an automatic impeachment and conviction, and they're removed from the bench. They're either acting as partisan activists to obstruct the president because they don't like him and his policies, or they are incompetent. Either way, they must be removed. Red pen of power. As always with these judges, we start with the histrionics. Oh, that's another thing this judge loves to do. She loves to quote from American history that's favorable to her desire to obstruct the president, from the writings of Alexander Hamilton, from writings in the federal papers. Guess what, folks? All of these things are not law. They're not law. They're history. They cannot be the basis for violating what is the law, the U.S. Constitution, and Congress's actually enacted statutes. Alexander Hamilton's passing opinion on some issue, unless it ends up embodied in our actual law, the Constitution or statute, is irrelevant. Irrelevant to any legal analysis. It may be useful to a historical examination, and a historical examination could be useful to a legal analysis where the law is ambiguous. But the law here is not ambiguous. Since this country was founded, she writes, Americans have disagreed about the appropriate division of power between the federal government and the 50 states. Yeah, sure, fair enough. And we've settled that disagreement. In fact, we fought a civil war to settle it, haven't we? And we have Article 6 in the U.S. Constitution that says the federal government's laws are supreme. The well-understood Supremacy Clause, that the federal government and the states are not on an equal footing when it comes to matters delegated to the United States. Now, the 10th Amendment says matters not delegated to the federal government remain to the people or remain to the states. But if a matter has been delegated to the federal government is supreme in that area. Our founders understood very well that there were some issues of law that could only be handled on a national level, not a state-by-state level. And those powers they delegated exclusively to the federal government. Among those, of course, are the role and function of the commander-in-chief. This tension between the federal government and the 50 states is a natural result of the system of federalism adopted by our founders. Yet not even the founding father, most ardently in favor of a strong federal government, she's talking about Hamilton here, believed that one state's militia could be sent to another state for the purposes of political retribution. She's mind-reading Trump here. Oh, Trump's only activating the National Guard, not for legitimate reasons, but for purposes of political retribution. In any case, this guy's opinion on what should be allowed with the National Guard is not law, calling such a suggestion inflammatory and stating that it is impossible to believe that a president would employ such preposterous means to accomplish their designs. Well, if you ask Trump, he'll tell you, I'm not doing it for purposes of political retribution. Sure, Pritzker and Johnson are shitbags, but I have a legitimate reason to call out the Guard. One, there's a danger of rebellion against the authority of the federal government, or it's actually in effect. Second, I'm unable to execute the federal laws with the regular forces at my disposal that I would use for that purpose. But this judge wants to ignore all that. Let's take a look. What is footnote 1 here? Footnote 1 is a lengthy quote from Alexander Hamilton in the Federalist Papers, which again are American history, but they are not American law. Our government's not bound by the essays written by Alexander Hamilton in the Federalist Papers, unless those arguments were accepted by the men who wrote and ratified our Constitution. But they're not there, are they, Judge Perry? Or you would be citing to that instead of to this essay. The plaintiffs, meaning Illinois and Chicago, contend that such an event has come to pass, that Trump has activated the National Guard just because he doesn't like them, not because he has a legitimate basis to do so. They argue that the National Guard troops from both Illinois and Texas have been deployed to Illinois because the president wants to punish state elected officials. How are they being punished? By the National Guard being deployed to protect federal property and personnel. How is that a punishment on the state of Illinois? I'm sure Judge Perry has thoughts. Illinois and Chicago further argue that President Trump has exceeded the authority granted to him by 12406. This is the primary statute Trump is currently using to activate the National Guard, that he's violated the 10th Amendment, and that the deployment of federalized troops violates the Posse Comitatus Act. Now, all three of these arguments are covered. This is one. This is two. Whoops. Sorry. This is two. This is three. So he's exceeded 12406. This is where Judge Perry's torturous interpretation of the statutory language comes in. Also, that Trump has violated the 10th Amendment, that this is a power reserved to the states under the 10th Amendment, and that he's using, or theoretically, speculatively would use, these National Guard troops to do traditional law enforcement functions, like handing out speeding tickets and going to domestic violence calls. These second and third arguments, the 10th Amendment and the Posse Comitatus, they're really only even legitimately on the table if the first argument is against Trump. Because if this first argument, that he exceeded his statutory authority, if that's not against Trump, well, that would mean he has statutory authority to delegate the National Guard, in which case, by definition, he's not in violation of the 10th Amendment, and he's not violating the Posse Comitatus Act. So I'm going to treat the 10th Amendment argument and the Posse Comitatus argument just very quickly, because I believe Judge Perry is explicitly and intentionally wrong on this first argument, that Trump, in her eyes, has exceeded 12406. And because she's incorrect there, these other arguments, the 10th Amendment and Posse Comitatus arguments, are not legitimately on the table. Before this court, the court of Judge April Perry, raised to the federal bench November 2024 after Trump's election, before this court is requested to issue a temporary restraining order and preliminary injunction barring mobilization of the National Guard, mobilization or deployment, over the objections of the governor of Illinois. For the reasons that follow, the plaintiff's motion for a TRO is granted. She says granted in part. It's not really granted in part. She gives them everything she wants. Trump is enjoined from deploying and activating the National Guard. Factual background. Now, I'm not going to spend a lot of time on this. She spends page after page after page going over incidents that have occurred around the Broadview ICE facility, the Immigration and Customs Processing Center, with the protesters, with the rebels, with the violence, because all she does is cite the view of those facts that is most favorable to Illinois. These are all peaceful protesters, that it's really not that bad. And anytime there's actual demonstrable violence that she cannot contest, she takes the view that, well, it was passing, or it wasn't that serious, or in other words, she's just minimizing all the violence and property destruction that's happened. Either it wasn't going on for very long, or it's not lasting right now, or it's all an effort. And what all of this leads up to is her simply deciding that her judgment about the seriousness of all these events, weeks of violence, violent protest, obstruction, impeding, property destruction, acts of violence against individuals, including ICE officers, she just concludes that, well, most of the time, like here, there's 200 protesters, but she'll say, well, but the other time it was only 15 protesters, 100 to 150 here, 80 to 100. These numbers in her are not supposed to be a serious threat to 250 to 300 customs officers at this facility. Just harmless protesters. It's no big deal. And what she is doing is she is substituting her judgment as an unelected black robe tyrannical inferior district trial court judge over that of the president. She also likes to spend a lot of time quoting the local police departments that are doing nothing to help the president. The Chicago Police Department, they are happy to tell the judge, of course, they work for the mayor. They're happy to tell the judge, well, in our opinion, ICE is not suffering all that much. In our opinion, it's not that big a deal. So now the opinion of the local police department that's not doing their jobs is supposed to override the authority of the Article 2 executive branch commander-in-chief. And she says she doesn't trust the representations of the federal authorities about what's going on. She says they made mistakes in some of their affidavits. She says they say these people are violent, but sometimes they arrest them and then they don't charge them. So I find that they are unreliable sources of information. Again, she's overriding the authority and the judgment of the Article 2 commander-in-chief as an unelected black-robed tyrannical inferior district trial court judge. The other thing she likes to do is point to Trump's social media posts as evidence that, oh, he's not doing this for real reasons. He's doing this because he doesn't like the spherical Governor Pritzker of Illinois. He calls him weak, pathetic, incompetent, doesn't like his sanctuary policies. It's all personal. They are disgracing our country, these sanctuary cities, Trump says, working on papers to withhold federal funding for these death traps that exist. As if a politician like Trump is not allowed to speak hyperbolically. He's not allowed to speak politically and communicating to the body politic of the American people. A president who's not a lawyer, not arguing before the court, is supposed to talk like a lawyer who's arguing before the court. It is outrageous. She is punishing a politician she opposes because he speaks hyperbolically. She says the courts have consistently upheld the lawfulness of sanctuary policies. But have they, though? Or is it not time? Is President Trump not allowed to challenge those lower court decisions? There's never been a Supreme Court decision that says sanctuary policies are lawful. It's not had a final adjudication. Isn't the inherently sanctuary cities impeding the federal immigration law by its very design? Plaintiffs, that's Chicago and Illinois, have demonstrated President Trump's longstanding belief that crime in Chicago is out of control and that federal agents should be used to stop that crime. So another thing in this opinion is this judge is completely schizophrenic about whether she wants to make a posse comitatus argument or not. Whether she wants to claim that she's prohibiting Trump from deploying the National Guard because he intends to use them for routine police law enforcement purposes, because he complains about crime in Chicago. Should an Article 2 executive branch president be stripped of his commander-in-chief authority because he's complaining about crime in Chicago, one of the most violent urban centers in America? Because the president believes that if the National Guard is deployed, that will have a negative effect on violent crime? Could that not be true even if they're not handing out speeding tickets and responding to domestic violence calls? Isn't it possible that the mere physical presence of the National Guard in Chicago around federal properties would have a mitigating effect on crime in the city? But this judge wants to interpret all these statements as saying, oh, Trump plans to violate posse comitatus. He plans to use the National Guard as cops. But then she'll say, as we'll see later, well, I'm not making that argument here. I'm not restraining the president's Article 2 commander-in-chief authority on posse comitatus grounds. I just want to spend page after page after page talking about his hyperbolic social media posts about crime in Chicago and the speculative possibility that he could end up doing that. And on that basis, I'm going to strip our commander-in-chief of his authority over U.S. military forces. This kind of hyperbole. Trump, I turned our great capital into a safe zone. Was crime in D.C. reduced? There's virtually no crime, he wants. Now I want to liberate Chicago. When asked at oral arguments whether the National Guard was being deployed in Illinois to stop crime, the White House counsel did not disagree that this was an objective of the employment. Does that mean they're going to be used as cops, or does that mean it's our expectation that crime will be reduced if the National Guard is deployed? In any case, it's all speculative. A theoretical possibility that posse comitatus could be violated is not a violation.